Istihsan is a source of law according to the Hanafis. Imam Shafi'i rejects it as a source and considers it void, for the method does not rely on evidence. Imam Malik is said to have used it as a source, and an occasional example can be found in his school. In reality, Istihsan is a method that deals with the conflict of laws in the system, and it provides a solution by preferring the stronger rule or principle. The source has, therefore, been referred to as juristic preference. In its literal sense, the word istihsan means to consider something good. It is also applied to mean something towards which one is inclined or which one prefers, even if it is not approved by others. ALSI says that istihsan is the giving up of analogy and the adoption of what is easier for the people. Technically, it has been defined in several ways. Al-Bazdawi defines it as moving away from the implications of analogy to an analogy that is stronger than it, or it is the restriction of analogy by an evidence that is stronger than it. Al-Halwani defines it as the giving up of analogy for a stronger evidence from the book, the Sunnah, or Ijma. From these definitions, it is obvious that istihsan means the preference of a stronger evidence over analogy. Al-Sarakhsi points out that some jurists have criticized istihsan on the grounds that analogy is being given up for the personal opinion of the jurist. He responds that this is totally unfounded, for how can a jurist give up a legally admissible authority for something that has no authority? In modern times, the words juristic preference may have implied something similar. It is to be noted that analogy is given up by the jurist only when he has a stronger evidence to rely on, and this stronger evidence is one that is valid according to the Sharia. Istihsan, he says, is merely the comparison of two valid pieces of evidence or sources and the preference of the stronger over the relatively weaker. It may also mean the restriction of one with the other. He concludes that giving up of qiyas is sometimes due to the text, and at other times due to ijma or due to the principle of necessity. A few examples may be given. First example, Abu Hanifa, on deciding the issue of the person who eats during a fast out of forgetfulness, is reported to have said, "Had it not been for the report by the people, I would have said that he should repeat his fast." What he meant by this was that strict application of the rules of fasting requires that anyone eating food has broken the fast. A report from the Prophet, peace be upon him, says that liability for three things has been lifted from my ummah: forgetfulness, mistake, and duress. This is a case of istihsan, where a text has been preferred over analogy, and by means of which an exception has been created. Second example, qiyas prohibits the contract of salam because it involves a delay in the exchange of food items listed in the tradition of riba. There is, however, the tradition from the Prophet, peace be upon him, that says that he made an exemption in the case of salam. Third example, similar to salam is the case of the contract of istisna or the manufacturing contract with advance payment. Analogy prohibits it on the basis of the same rules as in the case of salam. It is, however, permitted on the basis of ijma according to the Hanafis. Fourth example, analogy requires that ritually pure water should be used for ablution. In the case of wells in which dirt or carcasses of animals have fallen, following strict analogy would mean the non-use of these wells, and this would cause hardship to the people. The principle of necessity requires that use of these wells be permitted. This is done after observing formal cleaning methods. Fifth example, the general principle of sale requires that a thing that does not exist cannot be sold. In the contract of hire, the benefits or services that are being paid for do not exist at the time of the contract. The contract has been permitted on the basis of necessity, seeking support from the contract made by the Prophet Moses, as mentioned in the Quran. In all these cases, the consequences of the application of strict analogy have figured significantly in the decision, and the decision preferred was one that had healthier consequences for the people. It is to be noted that where an evidence for the rule existed in the Quran, the Sunnah, or Ijma, the rule could have been linked directly to this evidence without referring to the analogy that was set aside. The response is that Istihsan is a method that shows us that two pieces of evidence within the system may be clashing with each other, and it is necessary to note this conflict for maintaining analytical consistency of the system.